flawless days. Okay. We've gone from extremes. We went from horrible flawless to revolving door. And now we're coming back somewhere where now instead of 3 terms in House and 2 in Senate, you have 18 years in a single position, or a combination thereof. Which means you're going to get people who get voted in are harder to vote out. Incumbents have a statistical advantage. And right now our legislature has moved very far to the right. I don't think that would surprise anybody in this room, that the legislature moved probably further to the right than we actually thought it was going to. Those will be the hardest people to convince of the need for something that would traditionally be considered a Democrat platform. Tenant rights would be considered a more, not a business platform. It's not a pro-business platform. So the question becomes, from my side of the fence, going forward, how to structure it, how to bring a lot of these heavy hitters on board, get them to see that this is not going to hurt anybody. Because if you've got single house rentals, taking care of your house helps keep the value of the neighborhood up. And that's the question for the next 2 years, 2017. How do we bring the realtors together? How do we bring the big heavy hitters in the multifamily industry? How do we bring them into the room and bring them to a table? And that's a question I don't have an answer for today.
Thank you very much, Howard and Professor Flusser. Lynn, I'd like to give you an opportunity to respond to what Howard Warren just said, and then we'll open up the floor for questions.
Thank you. Two things occurred to me while you were talking, and I would have said these at the first, but I just they escaped my mind at the time. When you talked about the URLTA, the Uniform Residential Landlord-Tenant Act being run every legislative session, that is true, and it's been introduced in Arkansas in multiple legislative sessions. But in 2007, the pro-landlord sections of the URLTA were enacted in Arkansas. Only those.
I forgot that.
Every pro-tenant section was stripped out. So we have enacted half of the URLTA in Arkansas, and the Uniform Law Commission actually does not give us credit for having adopted the URLTA, which is totally appropriate. And the other thing that I wanted to say, if I had had time on my PowerPoint, I would have put some of the what can I say, the comments against the implied warranty of habitability that we've heard and some responses to those. But I think the most common rebuttal to an implied warranty of habitability is that Arkansas has the lowest rent in the United States. How many of you have heard that in here? Arkansas has the lowest rent of any state. That statistic comes from the National Coalition of Low-Income Housing. They have a website, and you can look it up on their website. And it is true, I looked on there 2 nights ago. They don't have the 2015 report up yet, and I'm surprised. It's a little bit late. I thought maybe it was being suppressed. It didn't say Arkansas was the lowest rental state. But I did a little research on that, and I went back 10 years, okay, which is on their website. It goes back to 2005. So since 2005, they do this every year. Out of the last 10 years, we've been the lowest state only twice. The other 8 years, somebody else is lower. Okay? And of those states that have been lower than us, most of the time, because we've only been the lowest 2 out of 10 years, of those other states, they all have the implied warranty of habitability. All of them, because we're the only state that doesn't have it. And they all give their tenants more rights than we do. So when you hear that argument, just think about that. Okay? I don't know what this year's survey is going to say, but and that's also, of course, assuming that there is this direct causal connection, which I'm not sure about that. I'm sure that there is a relation. I'm not sure it's as direct as is assumed by the people who make that comment. And that was the only other thing I wanted to say. Thank you.
Okay, it's time for questions, and I'm sure that many of you have some. Yes, please. Go ahead.
Talk to me.
Yes.
Yes, you.
Do you you guys have an assessment of how many legislators actually read the report?
Can we give the voting numbers? When I give you some numbers? There were 20 members of the committee, 17 to 3. Now, there's a neat website called followthemoney.org. Jason Peterson from Channel 7 in Little Rock reported that all 17 of the members who voted against the bill accepted at least $500, if not $1,000 or $1,500 from the Realtors Association.
And that's in addition to the large events that they also sponsor.
So that's something that's happened with issue 3. It used to, that was supposed to be to corral the lobbyists, but my little group we're mom and pop landlords. We own our own places. And we have lobbyists. That in previous sessions, I could go to lunch with an individual legislator, Lamoureux out of Russellville, because I went to Arkansas Tech. He and I could go to lunch together. We could talk about some bills. I could share the viewpoint. It was simple one-on-one personal communication. The way it is now, though, I can't do that at all. I can't even go to Starbucks and pay for my own coffee with him without a suspicion because my company hires a lobbyist. On the other hand, high-dollar groups can invite organizations within the legislature, a full committee, or the whole thing to a breakfast. A couple of years ago, the Realtors provided breakfast for the entire legislature, House and Senate, $37,000. So you're looking at, with issue 3, the mom and pop groups can bring a personal touch or out, and the high-dollar groups have more lobbyability than we do. How's that? I'm arguing for the ability to become a lobbyist.
Gentleman in the light blue shirt.
I have a question for Mr. Warren. And you had mentioned earlier that you were saying that since Judge Wright's declaration that the law was unconstitutional, there's about a 10 to 12% rent increase rate in Little Rock. I just wanted to compare that to, say, Fayetteville or some other big cities in Arkansas and what the rent rate increase has been like there, but I don't think anybody has declared the law unconstitutional there.
I don't know the rent numbers here in Fayetteville. I do know that when I lived over on Jean Fay Drive, if anybody knows where that's at, I paid $225 a month. That was in 1986. My daughter paid $400 and something over for the area around Leverett back in the early 2000s. I would not argue the point that some landlords took advantage of a situation to raise rents because this as an excuse. On the other hand, I can also tell you that when I started being a residential landlord, my electrician was $65 an hour. Now he costs $120. My plumber was $75. He's $95. My insurance went from $50 a month to $100. There's a lot more. As far as rent hikes, over time, there's a lot more than a single factor, and a lot of us will be looking at it as an economy that's still not working right.
Well, and that's the reason why I asked. I just wanted to make sure that, I had the impression that you were trying to suggest that because the law had been declared unconstitutional, that there's now this, height.
I am saying that in some respects because I started looking at Craigslist on January 21st, comparing my properties against competing properties in the neighborhoods, and yes, that's what I saw was 8 to 12 overnight. So, yeah, that happened to be January 20th. So I believe that this may have been a catalyst to kick it up. I believe there will be those landlords who took advantage of the situation to raise their rates anyway to match the market. And I'm sure there's those who look at it as a chance to catch up on losses. There seems to have been a catalyst. That may be the word I want to use. An excuse for some, a catalyst for others. I'll give the point. I'll give the point to you. I mean, if you look at economy of scale, if you look at Bailey properties with 500 units over off of Rodney Fair versus my 12 houses, yeah, they jacked up 10% across the board, but their rate of eviction hasn't gone up 10%. They've got deeper pockets than I do. Yes.
I have, two questions. One, I am a renter here in Northwest Arkansas. I rent from one of the boardings that you mentioned earlier. And I was really surprised when I moved here. I'm from Tennessee, and I was really surprised when I moved here and was getting ready to sign my lease, found this apartment, really liked it. So they required me to provide them direct access to my checking account, and they directly deduct my rent out of the checking account, and they basically said I didn't have any choice in the matter. And so I'm just wondering, is there, obviously, I'm assuming they have a legal right to do that, and kind of to the point earlier about if you were late with your rent, my neighbor was actually, he had just moved in, it was his first month, kind of, he had been there for a partial month, and then his first month he was actually out of town doing business, and for whatever reason that checking account transaction didn't get set up correctly. So he had an eviction notice on his door by 8 a.m. the next morning that didn't go through. And so I was just wondering also, in Tennessee, it was something like a 30-day process, I think, before you could actually receive an eviction notice. And so I was wondering if you could speak to kind of lengths of time in other states that you may have studied, if and before you could actually receive an eviction notice, and if you could speak to like this company directly deducting your rent out of accounts, and like could they come sweep your account if they wanted to?
As far as your checking account goes, you agreed to that. You were forced to, but you agreed to it. If you hadn't agreed to it, then they wouldn't have had to rent to you. So the question is that something that the law would not enforce against you? And I think in Arkansas, the answer would probably be, if you don't like that, go find another landlord. With respect to the notice periods, that varies from state to state. Some states give a period in which a violation of the lease can be cured, like maybe a 14-day period. I'd say 30 days is kind of a long period. The shortest period seems to be something like 3 days. Some states have special shortened, faster procedures if the landlord feels like there's imminent danger of destruction of the premises. They can go for an accelerated procedure. But there is a lot of variance around the states. But that is what our failure to vacate statute says. You don't pay it when it's due, your landlord can simply give you the notice. And whereas I think probably a lot of landlords, if you go ahead and cure the problem immediately, they'll say, oh, that's fine, I'll accept it. It's going to be less of a hassle to them if they think you're reliable to keep you in as a tenant than to evict you and try for somebody new. But I think there are some landlords out there who are kind of revolving door landlords, and especially if they're not happy with you for some reason, that's an easy way to get you out.
Arkansas law, Lynn mentioned a few minutes ago about the pro tenant side of the URLTA that was passed in 2007. 18, 17, and somewhere in the 300s, there is a 5-day grace period now in Arkansas law. Most people don't even know about it. Most landlords don't even know it's out there. But that might be in conflict with the eviction statutes. It is. So in other words, it's another gray smoke area in Arkansas law where it needs to be cleaned up. Otherwise, I mean, Lynn's absolutely right. And you agree to the contract. They have it. You don't have to take theirs. You can go to one of the other companies. When you get into an oligopoly situation, you will find that business practices start mirroring each other. And and not knowing the nature of the complex you live in, is it primarily student-level housing? Is it young adults getting started in the professional world? Is it older?
No, it's linked at Lowell, so it's like kind of rather professionals and blue-collar workers, and not a lot of students there.
I'm too small to allow that. I don't do credit cards either. I'm too small to afford the fees. Yes.
Yes, I just wanted to comment on the financial analysis over here. It appears that you're sort of double dipping on the vacancy. You're taking 25% out as a cost on the left side, and then you're counting it again month after month on the right side.
That's probably because of the speed that I wrote it up there. It's not meant as an income statement as much as a return on investment analysis.
Okay, Okay, but you are counting for agencies twice a year.
Yes, that's probably correct.
Also, if students, there's no cost over there for a background check or for the simple process of checking references. And yet you're assuming over here that you're evicting every year. So something's wrong with the business decision process there if you're having to evict out of state.
I agree with you completely. My average tenant stays with me 4 years, and my longest was 9.5. But you have to look at it somewhere. Basically, when you deal with the banks, as far as presenting financials, they want to see it on an annualized basis. And again, that's an extremely crude example. It's just to show how the break-even period will extend out further based on the change of the law. It's not perfect by any stretch of the imagination. And as far as the background checks and stuff, I actually charge a separated fee for that.
Professor, got it.
Thanks so much for this. So I'm wondering, can cities regulate this at all through their codes? For example, can Fayetteville put in place some of these protections for tenants?
That's what happened in Illinois. Illinois still has just a judicial implied warranty of habitability, but the city of Chicago, where I'm from, enacted an ordinance, and it survived a constitutional challenge. So yes, I would say the answer to that is yes. Could be done. Will it be done? So, another question.
That depends on if the state legislature wants to allow you to have the ability to vote on it for yourself. But I didn't say anything that nasty, did I?
Actually, that brings up another point that I could make. Another objection that you'll hear to this is the second most frequently made objection, is that some people, many of whom are realtors, favor local enforcement. That's what they say. Local enforcement. But the problem with that, what they mean by that is that if a tenant is unhappy about a repair not being made, then they can call code enforcement, okay? Well, number one, there may not be a code, and there may not be a code enforcement, okay? Because you only find that in cities and towns, and not every town even has a code, a housing code. Second, let's say the tenant does call code enforcement. Well, what's to prevent the landlord then seizing the earliest opportunity to get that tenant out of there? Frankly, if I was a landlord, that's probably what I would do, and there are ample opportunities for that here in this state. So, if code enforcement works, because the codes all started to be enacted at the end of the 19th century, then we wouldn't have an implied warranty of habitability today. But it doesn't work on an individual tenant basis.
Yeah,
So.
that makes complete sense to me. I mean, I was just thinking that, if you can't get it through the state legislature, then maybe we could get it through state.
Yeah.
That would be interested in.
I am told that is why Alabama finally enacted theirs, because groups started going out and going to the cities and saying, let's go ahead and enact these as ordinances. And the groups against an implied warranty of habitability were not happy at the thought of different warranties all across the state. And so they finally agreed on a very narrow, like ours, a narrow implied warranty of habitability.
Does that also help to prove the case that there was an undue amount of fear with some of the reforms? If you could have some good localized examples that had worked well, perhaps that's the approach to take rather than keep hitting your head over trying to work it at the state level.
Yeah.
Yes.
With the proposed civil eviction that when you talked about in 2017, you said the original court jurisdiction would be district court, is that correct?
We would like to put it there because of the filing fee difference.
So would they have the jurisdiction to hear that district court?
Only if the Supreme Court grants it.
Okay.
But what I look at is if you've got bipartisan, by group, bipolar, whatever you want to call it, if you've got both sides coming together and asking the ALC to look at this and say, we both believe, business and tenant, we both believe it is in everybody's best interest to allow district court to hear possession only, that's a good starting point. That's not one side versus the other, it's not us versus them, it's all sides going to the court saying, please look at this.
Yes. Yes, sir.
probably didn't work, but nevertheless, it made tenants look bad. So it is really very hard to establish some standards of habitability, and I'm sure Greg's bill would have been even better. And I sought help from outside groups, but it was no-go because of the tough life of the landlord. And Bernie and I are landlords, and I do have some of these difficult situations on occasion. But I think just for everybody here, a lot of this, and I'd like to hear what Professor Foster was saying, a lot of these problems, I think, are because there are no written agreements between landlord and tenant. I know people all the time that say, you know, my landlord's doing this or that, and I'll say, what does your lease say? Oh, I don't have a lease. I can't imagine having a tenant that we didn't have a lease between us. And yet, it seems to be fairly common. And I would also like to know, in the statute, you occasionally still see references to JP courts. I don't think we surely really have any justices in these courts, do we?
None that I know of. There are none that have jurisdiction over any part of landlord-tenant law at this point in time. No, it's either a district court or a circuit court.
Well, see, the Robbie Wills bill of 2007